morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justice Massing and Brennan will be the panel for all of the cases today. We have read everything. Each side gets 15 minutes. You needn't use all of your time. We don't entertain rebuttal. With that, I'll call our first case as soon as I find it. 25P 542, Commonwealth versus FAHNBULLEH. If I'm even remotely close to getting that right. Ganguly. Ms. Ganguly, go right ahead.
Yes, good morning, Your Honors. Tara Ganguly for VEE FAHNBULLEH. I've raised two issues for the court this morning, starting with the denial of the motion for new trial. I do think that the motion judge in this case committed a significant error of law in terms of the standard that she used. The SJC's cases make it very clear that in this type of case, for the prejudice prong, in order for the defendant to prevail on a motion for new trial in a Brady violation situation, there has to be a reasonable possibility, that the non-disclosed evidence would have made a difference. That is significantly different between the substantial risk analysis that the motion judge used. And I've set forth in my brief the reasons I think the motion judge was flawed in terms of the cases.
Hasn't the SJC said that there's really no meaningful distinction between the two?
They did say that in, I believe it's Toucheri, but I think there's a big difference between something that might have affected the outcome of a trial and something that causes a substantial risk of prejudice. I mean, to me, it seems the same.
Well, they're different words, but are they different concepts, really?
To me, it seems the same as just straight prejudicial error versus substantial risk analysis, and those are definitely...
Something that might affect the outcome would be a substantial risk.
If it might affect the outcome, it might be a substantial risk, but I still think the might have affected the outcome gives more benefit of the doubt to the defendant.
But at bottom, what we're talking about is more impeachment evidence.
It is more impeachment evidence, but it is the most significant impeachment evidence that did not come in any way. And
it's Peralta, he had the cooperation agreement, right?
yes,
So that all came in. I mean, that wasn't withheld, of course. But the defense counsel cross-examined him regarding that he didn't name the defendant in his interview with the police.
he cross-examined him, I would say, weekly, based on the information that he had. He certainly had the police report. If you read the police report, it's not the same. The police report doesn't go into the detail that the video recordings did. And I know Your Honors have probably watched the video recordings at this point. The video recording of Peralta, Officer Megan literally asks him, do you know some guy, first name V? Do you know some guy named V? Peralta says no, shakes his head no. That's not in the police report.
Did the judge give a Champa instruction for a cooperating witness?
Yes, he did.
Just tells the jury basically you need to especially scrutinize this guy because he has a deal with the government.
Yes, but I think yes, the jury was told to scrutinize this guy. But
he doesn't mention the defendant's name until trial, and he's got a cooperation agreement, and there's a Champa instruction.
He doesn't mention the defendant's name until trial is not the same as he was given the defendant's name and he rejected it. To me, that's a big distinction.
Suppose the judge got the standard wrong, to the extent that there's a distinction between them, as Justice Meade has asked about. The Commonwealth concedes pretty much everything else. What if we just apply the correct standard? Can't we do that and then analyze it on that basis? We'd have to send it back for the judge to figure it out?
I think you can apply the correct standard.
Okay.
And yes.
All right. And if we do that, then Talk me through how we get to where you want us to be if we apply the standard, if the words are slightly juxtaposed as.
Well, I think the Peralta's statements to the police are the most important. Derek's statements to the police are not, they're not unimportant. They're still important. We have two witnesses for the Commonwealth, the most important witness who had an amazing cooperation agreement, and the victim in the case. The victim in the case also never said to the police when he talked to them the day after, probably, when he's talking about, you know, the guy's knocking me around, you know, N-word this, N-word that.
Right.
And then he never mentions a name V, N-word this, N-word that. And then he gets to trial, and it's all VVV.
Sure, the Commonwealth says those, fine, even if you assume that, it's pretty overwhelming in that the car's parked outside, it's his car with his ID and his telephone, his cell phone, sitting in the car. And
Yes.
I want
how
to
do you- I'm sorry, go ahead.
Can we, on the V, can we just,
Sorry.
so he doesn't, he says the thing about the you know, shoot the guy in the police interview. He doesn't mention V. What in the grand jury minutes does he mention V?
In the grand jury minutes, he does mention V. We're talking about Derek, correct?
Yeah.
Yes. In the grand jury minutes, he does mention V, but at that point,
And how long after the police interview was the grand jury? I would imagine pretty soon. I would
pretty
imagine not
soon,
far.
but I know that at least Peralta had been to, Derek at least had been to a pretrial hearing for Peralta in Taunton District Court or something. Derek was engaged in what was going on with this case. Derek probably knew the names of who was being looked at in this case. So I'm not surprised that Derek used the name V.
Well, no, but did they, okay, wait, because Peralta didn't name your client until when?
Until he entered into the cooperation agreement with the DA.
So was V's name even available to Derek?
In terms of timing, I don't know exactly, but if Peralta,
I mean, you're suggesting that he got it from court somehow, but
or
if,
from the DA.
okay.
If Peralta gave the name V to the DA at that point, and then the DA is talking to Derek before his grand jury test, or, you know, somewhere all in the same mix. But again, when he talks to the police the day after,
The way that if that had been available, counsel would have argued to the jury, well, he somehow between the police interview and the grand jury learned the name, and you should be suspicious of that.
both Derek and Peralta.
Okay.
Yes.
And then we get back to Judge Brennan's question.
Which is
so-
assuming that to be the case.
Right.
How do you deal with the phone? And I know that's another issue for you on the authenticity of it, but the messages on your client's phone that seem to suggest he's got some role in this.
Yeah. You know, I don't think the car in and of itself
Right.
is enough. There was certainly they tried to do testing, or there was no testing that was back in time for trial, so there's no other physical evidence that puts the defendant in the house. His car is certainly there. And defense tried to say at trial that Jesse had taken his car and his brother had stayed home with him, et cetera. If I just look at the cross-examination of Jesse Peralta, and I know this is an entirely different case, but the name the guy who was identified as Prince had the trial a couple months after. And I know it's a different case, but I've reviewed it, and that cross-examination, because that defense attorney had these recordings in his possession, that is a much stronger cross-examination of Jesse Peralta than we have in my case.
Was he convicted?
Prince was convicted only of unarmed robbery, and my client was convicted of everything. Just briefly on the text message issue. I think the only text messages that Jesse was able to authenticate were the first initial ones where he identified a conversation between himself and Kevin Lopez, who is his cousin. All of these other text messages between these 5 phone numbers, not even necessarily individual people that we know were typing on the phones. There was a conspiracy, but authentication was never really discussed in the trial. The judge never made the preliminary determination regarding preponderance of the evidence. That's never in the transcript anywhere. The judge never instructed the jury about authentication. The judge
Yes,
only...
the defendant didn't challenge them.
Right, so it's a substantial risk.
So
I don't think
not instructing and not reviewing the standard of evidence to authenticate would come out of thin air, or
To be perfectly honest, I don't think defense counsel understood the issue of authentication. I think they were talking more about the hearsay exception and joint venture hearsay exception. That was discussed a lot. Authentication was never discussed. I don't think trial counsel understood it, so he obviously didn't object to it. Every time a text message was admitted, objection counsel, no. I just think it went over his head. And so obviously it's a substantial risk analysis. There were so many text messages here. There are hundreds of text messages here. Between and among 5 phone numbers and names on these phones that may line up to the individuals we're talking about, maybe probably do, but there has to be a finding that they do. There has to be a finding by the judge that they do, and then there has to be an instruction to the jury that you have to find this as well. And that never happened. And in
You're saying
terms,
even in the absence of a request for an instruction or of an attorney raising that as an issue? You're saying the judge sua
yes,
sponte should? Okay.
there are cases, Foster F., Miola, Alden, all of those cited in my brief, where the court talks about the importance of instructing the jury about authentication and how it works and how they should
did
look
they
at it.
say that the instruction is required sua sponte?
I don't believe they say that, no.
No.
But again, I can only work with what I have.
No, I
and
appreciate that, but we need to evaluate the circumstances of it, determine whether they could be authenticated based on the circumstances, and if not, was there a substantial risk of a miscarriage of justice? So
Well, in terms
why
of
aren't the circumstances here enough?
In terms of the prejudice, they were significantly prejudicial.
Well,
and
that's why they put him in evidence.
I understand. And they were significant, but I'm talking about if there was an error and we're talking about prejudice, the prosecutor, both in her opening and her closing argument, harped on these, for minutes at a time.
Right, but I mean, if there had been an objection, don't you think that there was enough there for if the prosecutor argue and the judge to find that there was a preliminary
I think for
showing?
maybe 3 of them. I don't think for however many messages are in there.
Well, I mean, once you confirm that it's the phone, it is the defendant's phone number, his phone, it's password protected with his social security number.
Right, but there are others. There's Christina O'Halloran was in these text messages talking. There's Jason Lopez who's talking. There's Prince, who was never identified. We don't even know who Prince was. There was a weird man who showed up saying he was Prince in the middle of trial, and everyone got confused. It wasn't just the defendant and one person texting. It was 5 people texting.
But, I mean, does whether or not it was who the other people was, does that really matter to your client's guilt or innocence?
In terms of whether they were admissible or not, yes, because of the information that was discussed.
So, so you're suggesting that to authenticate the text, they have to authenticate every single person on the text?
Yes, Your Honor.
Okay.
If there are no further questions, I'll rest on my brief.
Thank you. Mr. Nadeau.
Good morning, Your Honors. May it please the Court. Stephen Nato on behalf of the Commonwealth. I have to begin this morning acknowledging two errors. First and most seriously was the failure to provide the recorded interviews. In this case, that was a point we conceded. Below, the fact that there were recordings was referenced in the police report. There was also a specific request for any recordings from any witness who testified before the grand jury. There were only 3 witnesses at the grand jury in this case, so not exactly finding like a needle in a haystack here. So that is, of course, on us.
Is it in the record why they weren't turned over? Was it like a succession of ADAs handling the case?
Your Honor, as I represented to the trial judge below, when I spoke to the trial prosecutor, she's now in private practice, she had no specific recollection of it and would not have been able to essentially provide any links suggesting that we may have, in fact, provided it. And where there was a supplemental compliance filed in the co-defendant's case, in the absence of one here, I think we are sort of left with that. But the fact that it was named in the police report provided to the co-defendant, I think, shows that this was neglect, not excusable neglect, but not bad faith, not an attempt to suppress any evidence.
Not that it excuses the failure to turn it over, but just to be clear on that, I mean, they got up to the trial and, as you say, it's right there. And the trial attorney for the defendant didn't say, hey, where's that information?
Correct.
Other than filing the original discovery request that.
Right. There was no effort to follow up on it after receiving the report. That being said, the duty was ours.
Oh, fair enough. No, I have 100%. Absolutely.
And as Commonwealth versus Gilday says, that's specifically or particularly when there's a specific request, rarely, if ever, is the failure excusable. But as Gilday also shows that failure can survive even a harmless error analysis, and that's what we argue here. So that leads into the second error that we have to acknowledge.
The evidence withheld in Gilday was far more severe than here.
Yes, I agree with that. So even in that case, it could survive a harmless error analysis. I don't think that's what the law requires here, but I think the evidence is strong enough, and the quality of the undisclosed evidence being marginal impeachment value.
What's your assessment as to how central a theme in the defense or how central a point identification was?
Obviously central, but here the ID did not depend primarily on, or really much at all, on Derek's testimony. It was the co-defendant. His recording interview was largely consistent with what he was provided in the police report, and he was cross-examined. As to that, any discrepancy there, I would suggest, is merely cumulative. But he is one of the guys involved in this crime, and he says specifically the defendant was involved with me. But you don't have to take just his word for it. The defendant's car was parked outside. His phone was in the charger in that vehicle. Text messages on that phone, his phone, showed that he was involved in the planning of it. Authenticity of those messages.
Which exhibits are extracted from his phone, of the challenged ones?
I'm sorry,
Which text exhibits are derived from, are extracted from his phone?
I know I say which exhibits in the brief come from his phone.
You do? Okay.
I don't have the numbers right off. I think there's a series of them because they go into different time periods, including some discussion about the roommates. But I believe that's established through exhibits 30 and 31, which are photos of the phone taken from the charger, and the witnesses from there sort of link it up as to the defendant's phone, or the phone identified as the defendant's phone. I think other specific phones mentioned are Mr. Peralta's, which were recovered from his person, and Mr. Lopez's phone, which was just, I think, described as one of the other phones in the car. So there was specific testimony tying it to the phone from the charger. And again, the messages derived from that phone were both establishing his identity as far as arranging, the lease to his apartment that his roommate Marcus authenticated at trial, and then moving on into the text where he says, "I was born ready," and, weed and money as the object of this conspiracy.
You mentioned, I was going to ask you about that. If there's stuff in the words itself that identify the defendant. You say, so he mentions his own address?
Not his address, his name.
His name.
When they're arranging with this roommate Marcus, who again testifies, there appears to be some discussion he's having with their landlord that he needs their names for the lease. So he asked the parties on this group text to identify themselves, and the number associated with the defendant responds, V. Mickey FAHNBULLEH. And the phone, the registered owner provided name on the phone is Mickey's iPhone 6. And obviously the carrier information shows that the defendant's name is associated with that number. So again, there's evidence that he was involved in the planning of this, not just from the text messages, but there's testimony that there was in-person planning at the defendant's apartment where he lived with Marcus, and Marcus testifies for the defense, but acknowledges that, yes, these guys were in and around the apartment in this time frame. So, again, this is not a case that significantly or even substantially relies on witness credibility. Here, obviously, Derek suffered a brutal assault. There's, I think, no dispute about that here. Anything discrepancies in his testimony as to the confusion in that moment or what he may have added subsequently, I think in light of all the other facts, would have carried very little weight with the jury. And again, this was in contrast with Pope, which is a case that rose and fell with the believability of a witness. Here, there was substantial physical evidence tying the defendant to the crime.
In the beginning, you started with the errors you were confessing. What about the judge's use of the wrong standard?
Yes, and so that does seem to have arisen from somewhat confusing articulation in one of the cases, but I do acknowledge that she applied the standard for when there is a general or no request for the evidence. She should have applied the specific request, but given our position that the evidence was harmless beyond a reasonable doubt, I think the error in the standard was immaterial here. That said, I think if the court is inclined to overrule the judge, considering she was the trial judge, she should be given the opportunity on a remand to assess under the proper standard. That being said, I think the court can find that the error was harmless beyond a reasonable doubt on this record here. If there are no further questions from the panel, I will rely on the brief.
Thank you. Thank you both.
Thank you.
Our next case is 24P1348, Commonwealth versus Torres. Mr. Zendrowski.
Yes. Good morning, Attorney Matthew Zendrowski. I'm here for DANYAEL TORRES. And so I'm going to start with the first issue in my brief, which is in light of Guardado, the bench trial judge erroneously convicted Mr. Torres, where the arresting officer's credibility was raised and was at issue at the trial.
What aspect of the credibility was raised and challenged at the trial?
So I believe that essentially his memory issues, where he has a pretty clear memory of the stop and immediately stopping the defendant, but he doesn't remember, if this guy's hood was up. He doesn't remember what color pants he was wearing, what kind of pants. And then after he's arrested, he doesn't particularly remember much about this kind of show-up identification procedure.
So they would have related to identification, right? There's no issue on identification at this point, right?
So my argument is about the firearms licensure. And so I think, while it's connected to identification, it goes to Officer Christensen's kind of general memory issues where he's...
So is there a difference between a witness being asked a question and simply saying, yeah, I don't really recall at this time, and then the lawyer moves on to another question and never argues it and never mentions it again, does that factor in at all to whether his credibility was placed in issue, as opposed to he just didn't happen to remember that particular aspect of the case from however long ago it was, which is what color his shirt was, or what color his, I'm sorry, pants, or where he was standing when the show-up occurred?
It's not, I don't think it's a overwhelmingly severe, like, raising of the credibility, but I think it does sort of illustrate that this person had some issues remembering exactly what happened that day.
What about the Commonwealth's point that, I mean, it was a bench trial, so that's, I'm sure why, but it was a pretty short closing argument by a trial attorney.
Yes.
And to the extent he mentioned the police officer, he basically said, well, subtext, you should believe him when he says my client told him he didn't have a license to carry because my client's being honest, and the reason he would own up to that is because, although I'm not sure what the evidence was of this, he might have just picked up the gun off the street.
Right.
And they just, so how, I'm just trying to figure out how, in light of that, the officer's credibility is an issue. If anything, it seems to me they're saying, well, you should believe him because he's a pretty credible guy.
I think, I guess it depends on how specific or general you look at credibility. And so, well, he gives pretty clear, direct testimony that Mr. Torres says he didn't have a firearm. I think generally the credibility was raised through the kind of the memory issues. And so it goes also back to Bookman with there's a big or. And so was the firearms licensure at issue, or was the, officer's credibility raised? And so I think that sort of separates the concept of the licensure and the credibility. And
What's your take on Bookman? Is it, the Rule 23s are kind of in different places on this. I think you've both identified that. Is your take that Bookman says if there's any issue of credibility on any subject whatsoever, well, there it is, end of story. Or, as some cases that some members of this court have written, well, the credibility really has to pertain to the issue of licensure. I think there's
right.
one.
Actually, I had argued the Burgos case. So I would say that it's that or. And so the SJC in Bookman doesn't really specify. It would be nice if they gave us more than one sentence. But it just says, or the credibility was raised. And so my argument here is that it was raised. And it doesn't really matter how. And I think that the other unpublished decisions we can distinguish a little bit, because it seems like those are particularly tangential issues, or it's unclear, if they even impacted anybody's credibility, where it's just sort of really tangential out there. Where in this case...
Why isn't whether his hood is up or down tangential?
Yes.
Why isn't whether his hood was up or down tangential to whether or not he had a license to carry?
Well, I think in this case, it's the cumulative effect of the hood. I don't remember what kind of pants he's wearing. Then we have some specific testimony, and then Officer Christensen goes back to not particularly remembering what was going on.
So then should we not then measure that against the defendant's admission, which is corroborated by the police dispatch checking?
Well, I think, just back to the Bookman of the credibility was raised. And so I think that in this case, his credibility was an
Your
issue.
position it is if the police officer is impeached on anything, it's always harmless error.
I think impeached or enough to the extent that it would raise the credibility, where I think in the other unpublished decisions, it would seem that it didn't really get to the arresting officer's credibility, that it was really unconnected to any...
Yeah, well, I mean, unfortunately, there's a different three of us sitting here today.
Yes.
So I need to understand how a general impeachment on something not related whatsoever to his licensure should be important in the grand scheme of things when we're looking at the substance of the evidence against the defendant that he had no license.
Because I think that the question at the trial court judge essentially should have known, not his fault, but they should have known that they needed to evaluate that testimony that he didn't have that licensure against this person's memory issues. And so, against the fact that they specifically remembered this, but didn't remember much else, and so couldn't recall hoods, couldn't recall colors of pants, couldn't recall pretty much anything that happened afterwards.
Is it your position that every time a witness is asked a question and just doesn't have a specific memory, that is impeachment by definition? Because it seems to me that, well, I'll leave you to answer that question, and then have a follow-up on that.
I don't think so. I think with this case, it's again, the cumulative kind of nature of the lack of memory, where...
What made it impeachment here? Because typically, it seems to me, impeachment is when a witness is confronted with their lack of memory in some way, or an inconsistent statement that was previously made, or with something else. That's not what happened here. He was just asked a question, he didn't happen to have a specific memory of that detail.
Right. Well, I think it also isn't, with that Bookman language, isn't exactly impeachment. It's sort of, did the questions raise an issue of credibility? And so maybe those concepts are separate, but I'm arguing.
So, I mean,
I'm sorry.
Okay.
Justice Brennan made this point before in a different context, but should it matter that the defendant used this evidence in his defense, that he's an honest guy?
Right.
And he just found the gun that day.
Yeah, and he was telling the truth when
Right.
he said he didn't have a license. I mean, my argument has to be that it doesn't, because...
And then, okay, so why?
Yeah. So that the credibility was raised, and so the issue and the error comes from the trial judge not applying...
No, you told me it doesn't matter. I want to know why it doesn't matter. That the defendant used it to his benefit.
Right. Well, I think because it wasn't evidence, the closing argument, and I think that it's that, or was the credibility raised? And so perhaps that goes to the issue of, was the firearms licensure at issue? And I'm not sure that was or not, but I think that it goes to the issue of Officer Christian's credibility. And so I think there are two separate issues there.
So, with this, we're interpreting like 10 words from Bookman like it's the Bible, and this is like the Talmudic study of what the or meant in Bookman. But the other part of Bookman, it's the testimony that we're talking about is, and again, we have just a few words from Bookman. A police officer testified that neither the defendant nor the co-defendant had a license. So, from all we can tell, police officer says he doesn't have a license. Here, police officer said, he told me he didn't have a license. And dispatch confirmed that he didn't have a license. So it's not just the police officer's word. Shouldn't that make a difference in our Talmudic interpretation of whether credibility is?
Right. I think that for my argument, it can't make a difference. I think because it goes to, was he relaying that information correctly given the rest of the memory issues, and that was the kind of where the error has to stem from in my argument. And then I can turn briefly to the motion to suppress. I think that that issue essentially comes down to the snow, having recently fallen in the snow. I think that...
So on that, if all they had was young, white, male, not just young, but low 20s, black sweatshirt, coming over the Lord Overpass toward, was it Westford or Chelmsford? I'm not sure. I know the area pretty well, but coming over the overpass, and it was a few minutes ago, and the officer rolls up, and here's a guy just off the overpass, a quarter mile away from the report of the shot fired, with a black sweatshirt and fitting the description, other than the snow. You're saying as a matter of law that that's not enough?
I would say yes. I think with DM that it was a daytime, a weekend, a busy area.
It would have been helpful to say, okay, he was the only guy in the street, I suppose, and there weren't 100 other people, but even, so in the absence of that, you think that that is not enough for the police to just at least make an inquiry, stop them, say, hey,
I think,
can you hold up there?
I mean, inquiry or stop might be a separate kind of question, but I think it would be insufficient to stop. Maybe say, hey, I don't think, I think police could do that. And so, yeah, that it was a snowy day, busy time, and so that essentially that wasn't enough to provide us individualized suspicion.
The testimony, I believe, was that he, in addition to the description of his clothing and his race and age, that the snow on his sweatshirt is consistent with something having fallen in the snow, as opposed to snow falling on them. You'll agree there's a difference.
I would agree that they're, falling in the snow and snow on their person, but I think that that's a fine difference in the situation where it is snowing. And I would also point out...
But it's a contributing factor in that this is the guy that the callers are talking about.
I think that the fact that they had fallen in the snow was contributing, yes. I don't think it reaches that individualized suspicion. And I would also point out that the Officer Christensen testified that the person he stopped, or Mr. Torres, I suppose, had pants that had snow on them, but the description was for someone who had snow on their person, on their back, that had recently fallen in snow. But that it sort of did not match the location of the snow, where the snow was, where they had fallen, did not match.
What did the judge find as to where the snow was?
I believe the judge found kind of that they generally had snow on their clothes. So kind of they went more general with that, I believe. And if there are no further questions, I'm happy to rest on my brief here.
Seeing none, thank you.
Thank you.
Mr. Cohen, welcome.
May it please the court. Good morning. My name is Dan Cohen. I'm a 2L at Harvard Law School, appearing on behalf of the Commonwealth, and with me is Assistant District Attorney Casey Sylvia. Starting with the Guardado issue, Bookman does not stand for the proposition that an officer's credibility on their testimony of licensure is called into question whenever there's a cross-examination on an unrelated issue. Here, the Commonwealth introduced uncontroverted evidence, that's the standard introduced in Bookman, that the defendant lacked a license to carry a firearm. And as Your Honors pointed out, the defense counsel used that fact in closing argument to advance their own theory that the defendant was only in transitory possession of the firearm. So both sides seem to agree that this was true, that there wasn't a license to carry, that the Commonwealth proved that, and that that was credible and should be trusted. For that reason, this was harmless beyond a reasonable doubt. Both sides relied on it. Now, there is a little bit of a split in those unpublished cases as to whether or not the defense counsel needs to actually do any damage to the officer's credibility. But even in those 3 unpublished cases discussed in the brief, there's still the through line that there needs to be some sort of bearing on the licensure testimony itself.
So those are the unpublished decisions, but if we just read the literal language of Bookman, as Justice Massing said, I don't want to necessarily delve into more of a Talmudic examination. Having said that, it says there is nothing in the record to suggest that the defendant disputed this testimony. I think you get the check on that one. Or that the officer's credibility was in question. Should we extrapolate from that that any time officer's credibility is in question on any issue whatsoever, that raises a Bookman concern, or does it have to be specific, to your mind, to the issue of the licensure or the lack of licensure?
Yeah, I don't think it's a fair extrapolation of Bookman to say that any sort of issue of credibility, whether it's an impeachment or just failing to recall certain details like we see in this case, means that his credibility on licensure is challenged.
So how do we know where to draw that line? It seems we don't, since we appear to have randomly placed decisions on opposite sides of the spectrum.
Burgos seems to be an appropriate line, although unpublished. There were allegations from the defense that the detective had manipulated the recording of the interrogation, that he'd stop the recording when the defendant would say something damaging to the Commonwealth and would restart it, and essentially was fraudulently presenting this recording. And there the panel had significant concerns that this egregious conduct called the overall credibility of this officer into question, that we're not sure that we can believe anything that he says.
But did the turning on and turning off in any way relate to whether he had a license?
It relates to the truthfulness of the officer, which implicates his overall credibility and truthfulness challenge in manipulating this before the court. It does call into question the licensure testimony as opposed to just not recalling certain details about whether the defendant's hood was up or where someone was standing during the ID. That doesn't call into question. There's no plausible link there to the licensure.
So the police officer in Burgos was unscrupulous, if not deceptive, and as opposed to not remembering whether someone had a hood up or down.
Yes, Your Honor, we believe that there's a significant difference there. And those are just allegations from the defense, and that's why the panel felt that his credibility had been called into question at that point on any matter, because, again, that's such an egregious act to manipulate this recording that it does call his overall credibility into question. But here, we don't have that. There were those 4 details that he wasn't able to recall, 2 of which he just said, I'd have to check my report. I'd note that Officer Christensen wasn't actually the one conducting the show-up identification. He was standing with Mr. Torres at the time, and a different officer had rolled up in his car with the witness and had them identify in the car, and he wasn't present for that. And so it's not that surprising that he wasn't confident exactly where the witness was placed when they were in this police car, and he was just standing with the defendant. I believe at that point he was being treated with a medical issue, and so it's not that shocking that he doesn't remember this specific detail, and it certainly doesn't go towards his credibility on the licensure testimony as a point of fact. That wasn't contested at any point. There were no questions from defense counsel to challenge that. He testified that he asked the defendant point blank, do you have a license? And the defendant admitted that he didn't, and that he followed up with dispatch to confirm. And then we have, in both closing arguments, pointing out that Officer Christensen was credible on that point, that the defendant was telling the truth, that he didn't have a license to carry. And so that meets the Bookman definition of uncontroverted evidence. Bookman explained that what that means is there wasn't any sort of contesting of the licensure or there wasn't a credibility issue. And this seems to be a perfect example of that nobody disputed at the trial that there wasn't a license to carry a firearm. So with that, moving on to the reasonable suspicion, there were several factors that, as a matter of law, certainly passed the threshold for reasonable suspicion. First of all, there was a description. The motion judge credited Officer Christensen's testimony that he received a dispatch over the radio, that there was a white male, early 20s, black sweatshirt. He had fallen in the snow.
So same question I asked Attorney Zandrowski. If you take out the falling in the snow part of the description, in your view, is that enough? Would the police have had a basis to make the stop?
Especially given the exigency of the recent shooting, yes, that is enough. In Ducey, the court noted that adds an edge to the calculus of reasonable suspicion when there's a recent shooting, there's a threat to public safety, a threat of violence to the officer. And so especially when we have that corroborated by witness testimony, the motion judge credited Officer Christensen's testimony that right as he was arriving at this area, he received an update from dispatch saying that the person had just crossed the Lord overpass, they're heading right towards you, and that's right when he came into Mr. Torres. And so we see right there that it's perfectly corroborated by what the witnesses are telling dispatch and what they're relaying to the officer. So when we have a recent shooting, we have several matches of physical characteristics. We're only a quarter mile from the scene. Officer Christensen said that he arrived 1 to 2 minutes after receiving the call, so it was very short in time. And those factors together certainly pass the threshold for reasonable suspicion. There are no further questions?
The distance was, the quarter mile, is that a distance from where the shooting took place or where the Lord overpass was?
From where the shooting had taken place. He encountered Mr. Torres right as he had crossed the Lord overpass. It was at a 7-Eleven right past that.
So it's even closer.
Well, it was a quarter mile from the shooting. It was right at the Lord overpass where he was reported to be. So it was right where the report was, but a quarter mile from the actual shooting. Alrighty, I'll rest on my brief. Thank you.
Thank you. Thank you both. Well done by both sides. Thank you. Next case is 24P837, Commonwealth versus a juvenile. Please do not use names, or his name. Mr. Touches.
Good morning, Your Honors. May it please the court. My name is Jason Tauchis, and I am the attorney for the defendant juvenile in this case. The lower court erred when it found that the expansion of the stop and exit order and the pat frisk was lawful in this case based on reasonable suspicion that an occupant was committing a crime by possessing an improperly stored loaded firearm when there was no reasonable suspicion that the suspect, ZH, was in the vehicle, the firearm was in the vehicle, that there was a crime of an improperly stored firearm taking place. Reasonable suspicion in this case.
You said there wasn't reasonable suspicion that the juvenile was in the car?
There's no reasonable suspicion that ZH, there was, and I'm using the initials in this case because it's an impounded case.
Yeah, that's fine, but as long as you're talking about the same guy, when they pull him over, they see the juvenile in the car.
Your Honor, I'm talking about the owner of the Dolo Hustle account. Based on the facts in this case, the officers were looking...
I'm sorry, I misunderstood.
Should we presume that they were all juveniles?
No,
For the
Your
purpose of this conversation, so we can't use anybody's name. It's hard, because it's hard
Oh.
to navigate this when you have 9
Right,
people
right.
loaded into a car, albeit a Cadillac Escalade,
Yes, sir.
Escalade, and we can't use anybody's names. It's kind of hard to figure out how to see which guy's which. Or,
Yes, Your Honor.
Or if it's only one.
So,
So there's H, who's supposedly it's his Snapchat. It's J, who they decide it's his Snapchat once they do it. It's C, who they saw and recognized holding the gun.
yes, Your Honor.
And your client would be the juvenile.
Okay, that helps.
But C, the guy who's seen on H's account with the gun, they do trace him into the car, right?
So they trace C into the car, but they don't trace H into the car. They don't trace... and
Right,
they
no,
don't-
Right, he's not there.
right, he's not there.
And they don't check, reasonable suspicion broke down because there is a reasonable inference that H is the owner of the firearm. There's a reasonable inference that the firearm, when this was taking place, was in inner city weightlifting gym.
Let me ask you this. And the guy who was in the Snapchat a minute either before or after, but a minute before or after the live shot of what they say is the gun in some sort of felt or whatever it was, right? That guy.
That is C, Your Honor.
Right. They see C in the car before they stop the car, right?
Yes, Your Honor.
Okay. All right. And so can we, maybe we can't all agree, but my sense is that this really is a reasonable suspicion analysis from jump. I mean, they had a right to pull the car over because it didn't put the blinker on, but the bottom line was from the second they pulled the car over, this was an investigatory stop. It was not a, let's give them a ticket for using the blinker.
Yes, Your Honor.
Right? You were on the same page on that one.
I believe that they thought they had reasonable suspicion. I believe that
seems
it
to how
was
the judge
an
wrote it.
investigatory stop.
Okay.
But they didn't check. It was a reasonable inference that H was in the weightlifting gym and that the firearm was in the weightlifting gym.
Once they stop and they see J, the officer testifies, he realized that he was the owner of the Dolo Hustle account, and it wasn't Z.
Yes, Your Honor, that's an opinion and a convenient invention with nothing to support that opinion.
He testifies that he recognized him from the account.
That he recognized him.
Actually evidence.
He recognized him on the account, but he also recognized C from the account. He recognized the juvenile from the account, and he provides nothing in the record to support this opinion that it is J.
So if the judge makes that finding, which she did, you're saying that's a clearly erroneous factual finding?
Yes, Your Honor. It's an opinion of there's nothing to support that.
Well, his opinion is that he said, I saw that guy, and that was the guy on the Snapchat account.
Let's assume that it's not J's account. They still have the Snapchat story and pictures, and the juvenile's there, and the gun's there, and then they're in the car moments after they've seen the live story. Why does it matter whose account it was?
Yeah, because it's because the investigation from 2019, when they had the Snapchat account until now, they're under the impression that it is H who's the owner of this.
Right.
And they are looking, when they stop the vehicle, they are looking for H because they believe that he is the one who has the firearm on him.
Right.
But they did not check Inner City Weightlifting Gym, where they saw H, or they
They
had a
didn't have the
reasonable
chance to
inference.
because the Escalade was leaving with people in it who they were suspected.
And they had multiple officers and multiple vehicles, and all they had to do
You know, it's funny, I was trying to do the math. As many as police officers there were there, they were still outnumbered.
I understand that, Your Honor. It doesn't mean that they can't have one of the vehicles go to Inner City Weightlifting Gym and see if H is there.
I would think it's fair to say this was rapidly unfolding.
I'm sorry, Your Honor?
This was rapidly unfolding.
Well, it wasn't rapidly unfolding. It took out between half an hour from the time of the initial posting until they pulled over the vehicle. It was 7 minutes from the time that they left Inner City Weightlifting Gym to the time.
It was a matter of minutes between when they saw the firearm the first time, and then it was deleted, and then they see the firearm moments later at the gym. Not properly stored.
No, Your Honor, they showed it in they saw the Snapchat at approximately 3:50 p.m. It was, so 3:50 p.m. they see the DC. At 3:51 they see the picture of the firearm. At 3:54 they check, the officer checks the Snapchat account, and then 13 minutes later he checks it again and the firearm has now been deleted.
What's your take on the reasonableness of the inference that the firearm was improperly stored based on this little Snapchat? And I'm just looking at, mine's black and white, but the little picture of it just shows the butt of a firearm.
I don't believe that there's an inference that it's improperly stored. We don't know the owner of the firearm. We don't know whether it is a firearm under the law at this point, and we don't know whether or not it has a mechanical lock on it, or if it's under the control of the owner. So there's nothing to show that it's improperly
We
stored.
have to know all of those things in order for the police to have a reasonable suspicion.
We have to know more than just this one picture of what is the butt of a firearm. I don't even know if it's a reasonable inference that because the magazine is inside that, or allegedly inside based on this, that it's loaded.
I may have it wrong, but I thought that the judge's finding was, which credited the police officer testimony, was it had something to do with it being apparently surrounded by some soft material that looked like it was in a pocket.
It was either a pocket or a bag. And so, but there's nothing to show. It's pretty much.
If it were, would you agree that inherently having a firearm in your pocket or stuck in a bag of some sort is improper storage?
No, Your Honor, not if it's carried by a lawfully, by the owner, and if it has a mechanical lock on it. There's nothing to show. It's a very close-up of just the butt of the weapon, and there's nothing to show whether or not there's a mechanical lock on this.
Other than that they were in juvenile court, was there any record here as to the ages of any of these folks beforehand as to whether, again, by definition, they could not have legally possessed a firearm?
No, Your Honor, there's nothing in the record except for the defendant in this case, but in terms of C, H, or Z, if I'm getting that right, or J, sorry.
J. ZH are the same guy, yeah.
Yes, H, C, and J, there's nothing in the record to say that they were still juveniles. I understand that it's the juvenile task force, but we don't know when they had seen the individuals, and we don't know, there's no testimony as to the ages of the individuals.
You make an argument at the beginning of your brief that the body-worn camera footage is inconsistent with the judge's findings as to when the search of the vehicle began.
Yes, Your Honor.
I guess you're referring to like they're in the back of the vehicle, you know, touching stuff there.
Yes, Your Honor.
Why does that matter?
Because it shows that it was an investigatory stop, that they had already made the determination to expand the scope of the stop to get everybody out of the vehicle. They've already violated the Fourth Amendment and Article.
Wasn't the trunk open so the driver could get her identification out of her bag and back?
Yes, Your Honor, but that's not an invitation to search the vehicle. That's not an invitation for officers to go in and pat down and feel two of the bags in the back of the vehicle.
But the bags aren't defendants, right? And was there any evidence found that it gave them more reasonable suspicion?
No, Your Honor.
That's why I asked, does it matter? Why does it matter?
Well, it goes to reasonable suspicion whether or not a crime is afoot to order.
It doesn't advance, the pat frisking there, the searching doesn't advance their suspicion at all.
It doesn't, and it negates their suspicion because nothing is found.
Assuming that he touches her bag, are you telling me that it's improper for a police officer, when someone goes to a trunk to retrieve a bag, to show a license, that it would be improper to pat down that bag before she does so?
Your Honor, it happened after she went into the bag, and it wasn't the same bag that the officer was patting down. It was other bags.
If they had a reasonable suspicion at that time, based on all the other information, that there was a gun in that car somewhere, does that support the actions of the officer and just patting down the bags in the back to see, is there a gun in here?
No, Your Honor.
Why not?
Because it constitutes a search of the vehicle. There's no, and for there to be reasonable suspicion, there has to be some sort of particularized suspicion that it is in the vehicle, that it's going to be in that area of the vehicle.
And then to Justice Massing's point, which I don't know that you answered, assuming I agree with your proposition there, to the extent that it was relatively fleeting, but in any event they found it produced nothing, how does that inform our analysis of what they did moving forward from there?
Well, he's acting...
If we're already assuming that they were going in with an investigatory stop from the moment they stopped that car.
Yes, Your Honor. So he's trying to determine whether or not there is a weapon in that vehicle. He believes that he has reasonable suspicion, and so he's trying to create either more reasonable suspicion by finding something that would lead to him, lead to believe that there's a weapon in that vehicle or in that bag. And here there's nothing. There's nothing to support that. He felt one bag, and then he felt something that was like a computer case. And when
we'll say that they shouldn't have frisked those bags, because that's a frisk component as opposed to, right? I mean, suppose that the officer should not have frisked those bags. How does that inform, again, the reasonableness of removing each of the occupants of the car one by one based on the other information that the judge found? Because I don't think she factors that in at all into her conclusion that it was reasonable for the officers to pull the occupants out of the car.
So it goes to the fact that there is no individualized, particularized suspicion here. He doesn't know who's the owner of the bags. He goes through a few bags. There is no weapon found there, and therefore there is no individualized, particularized suspicion that any one person in that vehicle has an illegal firearm at that time.
So another question about your brief. You argue both that the exit order of your client is unjustified and that the pat frisk is unjustified. Does it matter? Does a pat frisk matter if they see a gun coming out of his waistband as soon as there's an exit order?
So, Your Honor, I would argue that because the officer, even though the back of the door is open, he is leaning inside the vehicle, and so under Supreme Court precedent, any observations, plain view observations at that point under Florida v. Jardines the officer's not in a place where he legally is authorized to be, because he's leaning inside the vehicle and looking at the defendant at that time. And so any observation he makes about that, seeing anything there, then that's still a violation.
If the exit order is valid, why isn't he in a place that he lawfully is entitled to be?
So the exit order I don't believe the exit order is valid, Your Honor.
I know, I said if it's valid.
If it is valid, then he can issue an exit order in order to pat frisk the individuals, but not the vehicle, Your Honor.
No, I asked if the exit order is valid, why isn't he in a place where he properly could be to observe things in plain view, like the gun in the juvenile's waistband?
Because he's going in through the rear of the vehicle and looking from when the exit order is given, and from his testimony, he states that he was in the back of the vehicle and looking over, leaning over, looking over the seats in the back of the vehicle.
After the exit order?
After the exit order,
Right.
yes, Your Honor.
All right. Yeah, go ahead.
Yeah, one more question I have is, and again, I know that you don't agree and wouldn't be conceding it, but if there was a reasonable suspicion that there was a firearm from that Snapchat in the vehicle, right, would the police then have justification to remove each of the 9 people in the vehicle so that they could then do a quick frisk of the interior of the vehicle for safety reasons?
I don't believe so, Your Honor, because...
How do they confirm or deny or dispel their concern that there might be a gun inside the car?
Well, they have to believe that their safety was in jeopardy for safety reasons, but also they don't know the ages. They don't know whether or not it's illegally stored. There is an adult, at least one adult there who's the driver, who was also seen leaving Inner City Weightlifting Gym and going into that vehicle, the female driver, who could be the owner of that firearm. And so there's no reasonable suspicion here of a crime being committed.
Thanks. Thank you.
Thank you, Your Honor.
Ms. Perez.
Good morning. May it please the Court, Molly Paris on behalf of the Commonwealth, asking this Court to affirm the denial of the defendant's motion to suppress. In this case, the scope of the stop was reasonable, where officers had a reasonable suspicion that there was an improperly stored loaded firearm in the vehicle. Reasonable suspicion does not turn or fall on whether the account was associated with whom they initially thought.
As a starting point, do you agree that the investigatory actions began at the moment of the stop, that they were already in investigation mode? It wasn't issue a traffic citation.
Yes, though they did observe the traffic violation.
Yep.
And again, here there were multiple factors that supported that reasonable suspicion, where 30 minutes prior to the stop, Officer Curtin testified and the motion judge credited that he'd observed a live photo of DC a minute later, followed by a live photo of what he believed to be an improperly stored loaded firearm.
Speak to that, please.
Sure. So Officer Curtin testified.
As in the improper storage part of it.
As the improper storage, yes. Officer Curtin testified that the firearm appeared surrounded by fabric as if it was concealed in either a pocket or a bag. He testified to recognizing the firearm, in particular the serrated handle, the emblem, based on his training and experience. And he also testified...
Can I hold you for a sec? Assuming for the moment surrounded by fabric as if in a pocket or a bag, is it your position that by definition that is improperly storing a firearm, regardless of other circumstances?
Yes, I believe that's...
So a properly licensed person can't just stick the gun in their pocket?
Correct. That's my understanding of the statute. And again, he also testified to it being loaded just based on his training and experience, seeing the magazine being in the firearm, that being indicative of it being loaded. Again, minutes later, after this firearm is posted, there's another live photo posted of the juvenile inside the Inner City Weightlifting Gym, and Officer Curtin testified and the motion judge credited as to the difference of what a live photo meant, that meaning a photo that was uploaded, captured and uploaded contemporaneously, as opposed to a photo that was from the camera roll or from memories, which had less investigatory weight or significance in their opinion. So here this was significant given that it was a live photo as opposed to a photo from memories or the camera roll. And minutes later, Detective Medina is on scene, observes 9 individuals quickly leaving the Inner City Weightlifting Gym, going into the Cadillac, and before the traffic stop, officers are able to identify DC, who Officer Curtin is familiar with based on his prior arrest, as being the front seat passenger. We then have the traffic.
Did they know his age?
There was no testimony as to the age, though Officer Curtin testified that it appeared to be a younger group. This court is also free to review the body-worn camera de novo, and I think that is depicted. But regardless here, there was reasonable suspicion for the improperly stored loaded firearm as opposed to reasonable suspicion for the illegal possession if this court chooses not to affirm on those alternative grounds supported by the record. And
How did the officer testify that it wasn't ZH, but it was JJ's account? How did they know that?
so the officer testifies that he believed it to be JJ based on observing him in the car, conferring with other officers while on scene, and having seen him previously depicted. And again, it's a little unclear how they initially thought that this Snapchat account belonged to ZH. I think it was just their belief at the time. It hadn't been necessarily confirmed or 100% verified. And there was also some testimony that the Snapchat could have been used by multiple individuals. But what they did know was that the Dolo Hustle Snapchat account had frequently been associated and depicted known gang members displaying firearms, and this was significant because it was the first instance where Officer Curtin had observed a live photo of what he believed to be an improperly stored loaded firearm, again, based on his training and experience.
Assuming that the officers had a reasonable suspicion that one of the occupants of the vehicle had at least previously improperly, sometime within a half an hour even before, in a different place, improperly stored a firearm, what do you say that gives them the right to do with the occupants of the car and the car itself?
Yes, Your Honor. So here what we have was essentially the live photo of the firearm bookended by the live photo of DC a minute before, and then a live photo of the juvenile. And when Officer Curtin approaches the Cadillac after the traffic stop, he recognizes the juvenile as that individual from the inner city weightlifting gym. And again, this is rapidly unfolding. The officers didn't go inside the gym, but they had reasonable to believe that that group was inside the car, where again, all 9 individuals exited the gym and went into the Cadillac. This wasn't a situation where certain individuals split. And
did they identify them? Any important ones from the Snapchat story or pictures as the people getting into the Escalade?
They didn't at the time, but before the traffic stop, officers were able to identify. They drive past the Cadillac and identify DC as the front seat passenger. And again, this is someone who Officer Curtin is familiar with, had previously arrested, and had possible gang affiliations.
So just again, you also?
Yeah, go ahead.
So back to my question, assume for the moment that I accept that the officers had a reasonable suspicion when they stopped that car to believe that at least one of the occupants, and maybe even 2 of 9, had been or had improperly stored a firearm somewhere else within the last half hour, 45 minutes, okay? What does that entitle them to do once the car is stopped with each of the occupants of the car and then the car itself? If it's
To confirm or dispel that suspicion, whether that firearm is...
That I get. So specifically,
Yes.
What could they do? Can they just start pulling people out? Do they have to inquire first? Can they ask some questions? Do they have to get identification? What is the most they could do from the jump, and what's the least that they were permitted to do, from your perspective?
I mean, I think they could have ordered the occupants out of the car earlier, but here they did what was minimally intrusive. They asked for identification. They identified certain individuals, including JJ's brother, who Officer Curtin recognized. They recognized the juvenile. They recognized DC. At that point, they asked for identification. The officers were also alarmed by the lack of response to Detective Romano's question, whether there were any weapons in the car. They found that concerning. And again, here, the juvenile here can really only challenge his expectation of privacy, his standing as to his person in terms of the exit order and pat frisk. But I think, again, the officers had reasonable reason to believe that the firearm was likely in the car, given the tight sequence of events. Had it been a day before, that would really change the analysis. But here, where it's less than 30 minutes between all of these things that happen. And then just briefly to the pat frisk, the officers see it in plain view, see the handle of the gun in plain view as the juvenile is about to exit the car.
So I was trying to figure this out, and I think I get it. It seemed very important to the officers to establish that one of the guys in the car was the owner of the Snapchat account. And I take it from what you just said that the reason that's important is because that further connects him to gang activity?
Yes, so there was, they initially thought that this Snapchat account belonged to ZH. I think that was just part of their initial investigation, but there wasn't much testimony as to why that was the case. There's a footnote in the motion judge's finding that at one point they thought it belonged to him because after ZH had been arrested, he had posted a video from the back of a police cruiser, and they believed that there was a very tenuous connection as to who was the owner. But once they realize that he's not in the car, they quickly pivot. Again, this is just a rapidly unfolding investigation, and at that point, believe that it belongs to JJ.
But again, that's important because, like...
It's less significant. I think what's most significant is the fact that there's the photo of DC, the live photo of DC. A minute later, the photo of the live improperly loaded firearm, and then minutes later, the photo of the firearm is removed from the Snapchat stories and replaced with the live photo of the juvenile. So I think where we have two occupants in the car seen minutes apart from this live photo of the firearm, that's what's connecting this nexus of the firearm likely being in the vehicle.
Is the inference that we're supposed to draw, and maybe that the judge did draw, is that the owner of the Snapchat would by definition have to have been present in order to post that live photo?
I think that's a possible inference. It's not a required inference. Someone could have taken the phone and
Fair enough.
snapped it, especially where it was a minute apart from DC and the live photo of the firearm. Unless this court has any further questions, I will rest on my brief.
No, thank you. Thank you both. We'll take it under advisement. We're going to take a short break. The next case is 24P443, Family Behavioral Health versus 387 Main Street Realty Trust. Mr. Potash.
Good morning, Your Honors. May it please the Court. Howard Potash. I represent 387 Main Street Realty Trust and Raymond Bond. This case is a commercial lease dispute between the landlord, my clients, and the plaintiff, which arose in Oxford, Massachusetts. The property was rented by a higher property of 5 units, was rented by a company, the plaintiff, that took care of autistic children, and the lease began in 2017. Around 2021, a dispute occurred between the parties, not over rent, but over certain incidents that occurred on the property. We argued today, and I was not the trial counsel. I did not enter the case until after the verdict.
Yeah, we can tell from your brief you're not the trial counsel. We can tell from your brief you're not the trial counsel.
We seek to overturn and remand the case because we believe that this is a rare case. We have a verdict, and the amount of the judgment is clearly excessive.
Was there a motion for remittiture or from a new trial arguing that the verdict was excessive?
It was not. The trial counsel withdrew, and there was he did not file before he withdrew any motions for a new trial or to remit the amount of the verdict.
I'm sorry, Mr. Potash, can you move that microphone closer to yourself? There, thank you.
Thank you, Your Honor.
There, yeah, much better. I mean, you raise, at the last section of your brief, you raise a lot of malpractice type claims about the prior attorney.
There is I am not involved, but there is a pending, I understand there is a pending malpractice case against the late attorney Conrad Schwartz.
You can't
in
collaterally
the Worcester Superior Court.
You can't collaterally attack this judgment.
I'm sorry?
You cannot collaterally attack this judgment with a malpractice claim in this appeal.
I'm sorry, I still didn't hear you, Your Honor.
How do you get you're basically arguing that the lawyer below, trial counsel, committed malpractice, and therefore we should reverse this judgment.
Well, I would argue that it was a one-sided case, and he did commit malpractice. There was no discovery.
But my question, I'm sorry, my
and
question, Mr. Potash, is can you stage a collateral attack by claiming malpractice within the underlying suit, which is before us? And if so, what case law says you can?
Well, what I argue today, Judge, is that the amount of the verdict is not at all reasonable at all, but with the damages that occurred in this case. The defendant did some incidents, but they did not cause the plaintiff to lose any patients. In the record, there was no patients who left because of what he did, and what he did basically bears no relationship to the damages. For example, he was allowed in the lease to use the shed because he ran his construction business and handyman business at the location. He used the bathroom in the main building that he leased once. He did urinate outside once because he was ill. He covered some security cameras. He didn't do the landscaping correctly, and he violated the court order.
What about his interactions with the children? Are we going to skip over that? It seems to me that is a bit of a issue here, perhaps, for your client and for you. Right? And when I say interactions, I'm referring, oops, a little bit loud, specifically to telling one of the children that she's pretty, or peering in through the windows. Maybe I'm using the word peering when you would just call it looking, but in context, I don't think that's unfair. But what about that behavior and then the response by family behavioral, which is say we really can't have these kids around this person?
I'm sorry.
Sure, was it an unreasonable response for the health center to say that they really didn't feel comfortable having the children around your client after he was engaging with children and talking to them about how pretty they are, especially a special needs child such as this who had maybe some particular sensitivity and/or peeking, peering, peeping, however you want to characterize it, into windows where the children were? What were they to do?
I believe, Judge, that he denied that he was peeking. He was just doing maintenance on the property, which he had a right to do under the lease and obligated to do under the lease. And I believe the characterization that he just, when he was in the building, that he just talked to one child in a friendly manner. He didn't do anything that was offensive, and I don't believe was any evidence, as I read the transcript, that any patient, anybody left the facility and didn't go there because of that one incident. I don't believe, and I would point out as damages that they're clearly excessive because the jury considered, and I admit there was no objection by trial counsel. He didn't object to anything. He didn't file any motions in limine. But for example, the plaintiff continued to pay the entire rent for the term of the lease, and the jury considered $108,000 that should be returned in rent, but the plaintiff was there the entire time, and they were running their business. They did open a second location in Auburn, Massachusetts, but there is, in the transcript, there is in the record that they couldn't handle all their patients in Oxford, so they were opening a second location anyway, and I don't believe that there's sufficient damages anywhere near $1,963,000. I would value this case much lower, and I would point out there was.
I mean, you don't have to look at it at the 600. It's like more like 600,000.
It was
right?
$674,000, and I would point out that the damages that were put in by the executive director. He said he lost $580,000, but that didn't reflect profit. That was his total sales. He had expenses that were not considered by the jury, and his. Actually,
I didn't see in the materials we have here the jury instructions. There was a trial. The trial transcripts were ordered for the first 3 days of trial. We don't have the transcript of the jury instructions, do we?
I did not include it. I did not include it.
So we don't even know what the jury was instructed.
I do not know, except that I believe the judge gave standard instructions on breach of contract and on 93A. And I would argue, Your Honors, that what happened here doesn't meet all the standards of 93A. What he did was in some cases improper, but I don't believe it rises to deceptive practices. For example, when he used the bathroom in the building and when he urinated near the shed, it was because of illness, ongoing illness that he has, and it was a necessity. It was not a deceptive practice, and he was using the shed, but he had an absolute right under the lease to use the shed, and that's where he operated his business. That's where he got his mail. And of course, after the preliminary injunction, he was limited on when he could go there. But the defendant, the plaintiff, occupied the premises for the full term of the lease. They paid the rent. They operated their business there until they moved, and there is nothing to show that they suffered any reasonable damages in this case. Now, certainly there is some value and there is some damages for what he did, but and I would point out that there was there was an attachment in the case by the trial judge, and a request for an injunction, and she valued and entered the attachment for $100,000. There was another hearing on a contempt by another judge, Judge Daniel Wren of the Superior Court, and there was some mention that he thought the case was worth around $50,000. The rent was about a little less than $10,000 a month. And many judges, when they're dealing with breach of contract with a landlord-tenant, they look at the amount of the rent. They look at 3 times the rent for violations. If you look at all the violations, I think there would be somewhere around 5 or 6 violations. That would not bring you anywhere near $674,000, which is, and I agree that a verdict should not be set aside unless it's clearly excessive. And unfortunately, in this case, the defense counsel did not present any witnesses except the defendant, and he didn't adequately, unfortunately, try the case or deal with damages. But we would argue that the amount of the judgment with interest now over $2 million is clearly excessive as against what was alleged and proven at trial, and by 8 to 10, 12 times, and clearly not in the ballpark of what this case was worth. And as far as 93A, I would respectfully argue that there was no intent. There was no intent on what he did. He simply was acting improperly in violation of the lease, but it didn't affect the occupancy of the business. And the tenant, although they had another location, did not move out, did not stop paying the rent, did not say that the building was not being used for its purpose. And again, I would argue there was no evidence that anybody, no parent, no child, left using the facility and giving them business behavioral health because of what Mr. Bonneville did. And I believe there's no question that, in my mind, that in other parties that there was malpractice, but not the amount of damages is clearly beyond what a reasonable jury would find. If there's no further questions.
Seeing none, thank you.
Thank you very much.
Mr. Hennessy.
Thank you. Good morning, Your Honors. Attorney Chris Hennessy on behalf of the plaintiff appellee, Family Behavioral Health, Inc. Your Honors, as you've heard, there's essentially 2 arguments here. Number 1 is trial counsel for the defendant committed malpractice. As you heard, there's a pending malpractice claim. And then separately, the other argument is the jury in its discretion got it wrong. Our position at trial was Mr. Bonneville's behavior was outrageous, and the jury agreed, and the jury awarded damages accordingly. This appeal should be affirmed because the appellant procedurally waived virtually all arguments, and even if preserved, the jury's verdict was amply supported by the evidence.
I may have missed it, but did you address the malpractice argument in your brief?
Well, I think what I argued in the brief, I didn't argue about, I didn't raise the issue of collateral estoppel, which I think the court.
Not collateral estoppel, collateral attack.
I did raise that this is, the brief states that this is essentially a legal malpractice case brought, and that is stated in my brief, Judge, but I didn't specifically raise the question.
So is it proper for him to challenge the judgment in this case by claiming the lawyer below committed malpractice?
No, absolutely not.
Oh, I was hoping to read that in your brief, that's what.
Well, thank you for raising it. I think the court can address it anyway, but in effect, I think overarchingly my arguments on waiver and all the other arguments directly relate to the appeal itself and why those arguments are not properly preserved. I mean, effectively, if the damages were excessive, there should have been a motion for a new trial. We have pretrial conferences, we have pretrial memorandums, we have motions in limine, we have objections at trial. The whole idea is to raise these issues before the trial court and not for the first time on appeal.
Understanding that, I have just a couple of background questions. The damages award was based on lost profit plus payment of rent?
Correct.
So how does, I understand the lost profit piece. Why is the payment of rent also recoverable?
So there was no overlap or double dip, if you're asking. There was payment of rent during the time that they were there, and then there was an additional year of time which the lease was extended. I believe that was the $574,000 was the lost profit. That was the time when they decided to move their entire operation over to the Auburn location. And the testimony before the jury was that they had a full waiting list. They had planned on putting.
No, I understand the profit part. I understand. I want the rent part, the $108,000 for rent.
It was for the period of time before they moved operations over to Auburn, and that is supported in the record.
So basically they're paying rent and not getting the full benefit of being there. Is that the theory?
Correct. And notably, the jury cut back the damages. It's not clear what component, whether it was the rent itself or the lost profits, but we had asked, the jury cut back our damages about $20,000. So they clearly went through a calculation and determined, whether it was the fact that some of the clients remained for a period of time or whether they thought it was a double dip. But that again goes to the sound discretion of the jury in affording damages.
And what was the factual and legal basis of the 93A claim?
Sure. So the basis of the 93A claim was that firstly, the breach of the implied covenant of good faith and fair dealing, as well as the tortious interference claim. The behavior was intentional. It was willful. The record before the jury was that this is someone who, despite efforts by my brother to minimize the conduct, this is someone who is coming in at nighttime, sneaking around, taking photographs, approaching children. There were irate parents calling, and that's in the record.
Excuse me, can I just a quick question, and it may be in there, I just missed it. Was this a program where the clients were residents, or was it a day program?
Day program.
Okay,
yeah,
sorry, I'm sorry to interrupt you.
Sure, and these are children, young all the way up to adult-aged individuals, severely behavior issues. There was significant testimony about the conversations that my clients had with the landlord during the time they signed the lease, were engaging about how important it was to preserve the sanctity of the therapeutic environment.
What was the suggestion as to what he was doing there at night when no one else was around? Or you just didn't know?
He was taking photographs, he was poking around. Again, he approached an individual, and then his response when they raised these issues was threatening to evict them. And then the important, with respect to willfulness, when he used the bathroom, he barged into the premises and used the bathroom, and they pulled him aside and said, hey, gee, we're having open sessions here. You can't come in and use the bathroom. His response was, well, maybe next time I'll go outside. And then, sure enough, the next event is him urinating in front of the playground, in front of the children. And it's important, you've heard that the evidence was he had medical issues. He denied urinating. This is a fundamental credibility issue. He lied to the jury, essentially. We had a video of him urinating against the side of the shed. The defense was not I was ill or I had cancer or I had a issue. It was I didn't do it. And the jury didn't believe that. I think there's, and then he went in, he was covering up security cameras. All of this conduct would give rise to a clear 93A violation. And I think it was supported in the record, and the jury properly found that issue. So, in summary, we've been waiting to collect on this debt for over 2 years. The defendant has filed bankruptcy. As soon as we tried to question the value, he's now withdrawn the bankruptcy. That stayed this. The latest argument in the malpractice case is that this appeal, there's no final judgment, so we can't attach the assets from the malpractice. So there's been delay upon delay. We just want to move this on. I think the record clearly supports that the jury got it right here.
Can you speak to your request for appellate attorney's fees? Are you requesting them as under 93A, or are you requesting them under our rules, or how are you? Thank you.
The purpose, the 231-6F claim is really because I think there's no valid basis of this appeal. The purpose of this appeal is to delay this case, and that's transparent. Again, we had a bankruptcy was filed, it was withdrawn on the eve of evidence. Now we have delay upon delay, and there's no sound basis for this appeal, and that's the purpose of the attorney's fees. Frankly, Your Honors, I just want to get this judgment final and proceed in collection because my clients have been waiting for a long time. If there's no further questions, I'll rest on my brief.
Seeing none, thank you. Thank you both. Take it under advisement. Our next case is 25P468 SK Management Company versus TRACY Castellanova. So, welcome to the appeals court. You've been here at least to see this morning's arguments. You get 15 minutes uninterrupted, except by the questions from us. Yeah. And when there's a minute and a half left, that yellow light will come on. And with that, go right ahead.
Okay, may it please the court. My name is TRACY Castellanova, and I am the appellant, representing myself. I'm trying to think. Sorry.
Maybe it'd be helpful if somebody asked you a question. So let me ask you one, okay?
Sure, go ahead.
So you argue that the, I guess it'd be the landlord, but that the plaintiff originally did not have standing because it was the management company as opposed to the actual owner or the company that was the landlord that served the notice. Is that your argument? Am I understanding that correctly?
Well, that's part of it.
Okay. Why do you say they didn't have standing? I guess is my question.
They never produced anything saying that they had a right to it. And in my lease, where it says that I signed this lease with Heatherwood Housing Associates as the landlord owner, it doesn't specify that SK Management is the lessor. even though they say it is the lessor. And my attorney, I know he mentioned it in court, in trial court, and the judge just blew it off. Oh, I'm not getting into this. That's what he said. For some reason, I don't see that in the transcript, which was odd. It wasn't transcribed. And my attorney had said something about that, my trial attorney. But yeah, I was saying that they didn't have standing to sue. But I have another thing that I wanted to bring up is that in my brief, I did mention a lot about a grievance. It was, I was told by my trial attorney that they had discussed it and I was not entitled to a grievance. Well, after trial, I called Rural Development and spoke to Megan, and Megan told me that everybody is entitled to a grievance. So I was misinformed about this grievance, and it is in my brief how Jennifer McNeil, who's the property manager, should have known that I was entitled to a grievance and should have put it in my lease violations that I had received. That she should have said.
I'm sorry to interrupt, but so your attorney, you're represented by an attorney at the trial, and the attorney gave you advice that
Legal
you,
aid.
and they said that you didn't have that claim.
He
So
said they were
therefore-
all in discussion, and I wasn't entitled to a grievance.
Because there's a form that you fill out with your counterclaims, and there's a checkoff box for grievance, and it's not checked off, and so that's why. It's because legal aid said that we don't have that claim.
Well, legal aid told me that the attorneys all talked about it, and I wasn't entitled to a grievance. That's what they said. That's what he told me. And when I spoke to the woman at Rural Development, which is a federal subsidy, and so what the court should have done was follow the federal regulations when deciding my case, and that was not done also. According to the Supremacy Clause of the U.S. Constitution, because I live in federal housing, which is rural development, they should have followed federal regulations when judging my case or deciding my case, and that was not done.
Ms. Casanova, you were there 33 years?
Yes, 33 years.
Are you still there, or did you have to move out?
I am still there
You're still
because,
there. Okay.
because I did the appeal.
Yep. Just want to make sure you
That's the
hadn't
other thing.
moved out regardless. or
Yeah,
had moved on.
I was going to say that. I have been living in this rural development for more than 33 years. It's like 34 years. And I have never, even I've had lease violations, and they have never acted upon them. And their lease violations, they'll issue you one even if they don't have proof.
Well, I saw some of them
if
were
somebody says
putting your bike in the wrong place or hanging
Yeah.
Halloween decorations or. Okay.
And
Did they give you, prior to the April notice to quit, did they also give you violation notices about unauthorized occupants?
in 2019, they did, but it wasn't about the same one. They have to be exact, like, okay, like I got this, the lease violation that says I have 3 people. It was Russell Casanova, Chloe Bedarzik, and an unnamed man as alleged unauthorized occupants. They have to be specific. That was the first one that I had received for those. And I tried to cure that by writing an email, which was a proposed email, like a proposed exhibit. And that email shows that when I tried to cure the lease violation, she never even written me back. I tried to cure that twice. Once when I received the lease violation and once when I received the notice to quit. Neither emails were replied to by Jennifer McNeil.
Are your emails in the record that you gave us?
My emails are in my appendix.
Okay.
But they show that she never even replied. They had no intention of letting me cure it at all, and they're supposed to. And that was a first alleged unauthorized occupant lease violation. Normally, they will give one and then give two. If you follow the federal regulations, they aren't supposed to do adverse action on your very first accusation. Like, they shouldn't have done that. And then the next lease violation was the cameras. And that was not even a lease violation. I am responsible for the light bulb that goes in the socket to their fixture, which is attached to the house. And I pay for that socket, the electricity. I run that, and I put in a camera light bulb. Because I'm supposed to be in control of that. And there was another piece of evidence, and it was emails, because me and my neighbor, we were using the same camera light bulb. Well, their property manager, Jennifer McNeil, she asked for the footage from our camera light bulb to see fire down at a tenant's walkway, because the tenant had lit a fire on a walkway. So she asked for the footage from our camera. And then what do you know? Now she's trying to evict me for that camera that she wanted the footage from. That was one of the other lease violations. And the third one, it was never even discussed. My son's income was never even brought up. And the fact that he was going to school at the time, he had income. And there are, federal regulations about that. But the main thing that I wanted to talk about was that the judge misapplied the retaliation law.
So can I ask you about that, one question about that?
Yes.
You testified that your lawyer sent a letter about your claim that you slipped and fell and hurt yourself on the ice. Was on the ice, right? Or in the snow?
What?
That you slipped and you fell as a result.
Yes, I
right.
slipped and fell on ice.
And then, as I read your testimony when you were asked by the other lawyer, you said, oh yeah, actually they sent it to the wrong box, post office box number.
Mm-hmm.
How did that give the landlord notice of your claim such that it raised at least the issue of
But
retaliation?
when you're P.O. box and you're at a small post office, they know your P.O. box. They know that this P.O. box belongs to this. So,
So it wasn't like it went to corporate headquarters and they had little corporate boxes. This is actually a post office. Is that right?
it went to the post office.
Okay.
And it's P.O. Box 250, and that post office knows that SK
Right.
Management has that post office box, even if it says P.O. Box 50.
But okay, so it was sent to 50.
Yes.
And you're saying that you're saying the judge should have just assumed that the post office would have known and stuck it in the right box?
Yeah, most post office do. I actually went into my post office and I asked, and she said, oh, yeah, if we know your post office box, even if it's wrong, we'll put it in there.
Well, assuming for the moment that that's not necessarily something the judge could do, what do you then say to the landlord's argument that, well, we didn't have notice of her claim, so how could we be retaliating if we never got it?
If you look into Judge Cavajal's judgment, he said corporate did receive it, if you read his findings. And if corporate received it, it's under imputed knowledge doctrine that Jennifer McNeil, who's property manager, should have known that I had filed claim against SK Management.
Okay.
If you read his judgment,
Yep, I'm
it
reading it
says
right
that corporate had received it, but Jennifer feigned ignorance.
Was there also emails before the note that? Did you also send emails about slipping and falling?
Oh, yeah. I had sent an email letting them know that I had slipped and fell because it wasn't taken care of by their caretaker, the walkways. And I had broke my fibula. And it was 88 days after the February 1st of them sending out the notice of claim that, what do you know? They sent me lease violations like I said, one was for alleged unauthorized occupants, and Russell Casanova is my ex-husband, and he visits his daughter. He does not live with me. We are divorced. And SK Management sent him a denial letter for housing to his address where he lives at, his sister's, and he got it. And he proved it with his ID as well, that he lives at her address. And Chloe Bedarzik is a 13-year-old girl I do not have guardianship of. I was allowing her to be dropped off in the morning and put on the bus, and then she got off the bus and she was picked up later. They were trying to add on occupants. They tried to add on a bunch of people 4 months after the notice to quit. That was irrelevant. They weren't even named in the notice to quit. And if you go by the federal regulations, it's 7 CFR 3560 in that area. It says that when a
Can I just ask you another question, just so I'm clear? I'm looking at Exhibit A, which is the emails about the moving the car.
yeah.
Okay, and you initially email them and say, basically, I'm expected to move my car, but it's blocked in because somebody plowed
I
it.
couldn't, they plowed my
Right.
car in.
And then they respond, hang on. They say that you fell, and they say, well, sorry, you broke your leg. I'm paraphrasing, but still your responsibility to move the car. And then you say, well, that's fine, but they didn't have to plow me in and all that. Is there something beyond that email? Is there a different email where you indicate that you're going to sue them or make a claim against them for the injury, and you're not just talking about, hey, why should I have to move my car since you
I filled out an incident
plowed it in?
report
Okay.
as well.
And that's in the
I didn't write
record?
that I was going to sue them or
Okay.
file a claim. I hate to bring it, but like 3 years before this happened, my son slipped and fell and broke his leg there too because of the caretaker. So I said, you know, if that happens to somebody else in my family, and what do you know? I did.
Okay.
I just decided I was going to do it because he just is negligent taking care of the walkways. He does not stay on top of it. And a lot of people at my complex are on Social Security for disabilities. And that is his job to do it. We do try to do it ourselves, but some people are disabled and can't do it. But yeah, I do feel the other thing is SK Management had no evidence to what was in the notice to quit for the reasons to evict me. They had no evidence that Russell or Chloe or an unnamed man were living with me. None. They were on a witch hunt to get something on me, so they provided photos and videos of people 4 months after the notice to quit and saying they were living with me. They were just trying to find anything they could to get me out. That's how I know it's retaliation, as to like just the fact they were consistently coming at me. My friends would arrive and the caretaker would run out with his camera and like his phone camera and video them. And it was becoming uncomfortable.
I'm afraid you're out of time now.
Oh, sorry. Okay.
No need to apologize. Thank
All
you.
right. Well, thank you.
Mr. Coletti. Yes, please.
Good morning, Justices. Anthony Coletti for the plaintiff, SK Management, lessor and managing agent for Heatherwood Housing Associates, LP, doing business as Heatherwood Apartments. I'm before you today asking that you affirm the judgment of the Central Housing Court in the summary process eviction. As you're aware, this was a cause-based eviction. There were several allegations in the notice to quit, including unauthorized occupants, affixing items to the exterior of the property, as well as unreported income. And that unreported income can come from multiple areas, between not reporting one of the tenant's income, as well as allowing additional people to occupy the property and not counting their own income. So it comes from different areas. One of the biggest issues before the court was this allegation of retaliation. 239-2A.
Mr. Coletti, can I ask you,
Yes, please.
before we get there, do you agree that a management company cannot file an eviction on
No.
behalf?
No. So this is the Hatcher decision. This is the Hatcher argument. So what we had in Hatcher was you had an individual representing a property management company, but the decision in Hatcher said a lessor or an owner could commence a summary process case, but they needed to be represented by an attorney. Now, if you review the notice to quit, you review the summons and complaint, you review the housing court docket, our plaintiff name is SK Management Company, Inc., lesser, and managing agent for Heatherwood Housing
So
Associates.
wait, does it make you the lesser because you say lesser when the lesser on the lease is called Heatherwood Housing?
Well, two things. If you look through multiple documents, through the lease, payments are made to SK Management.
But just because the payments are made to a management company, does that make them lesser? Because I'm looking at the lease, and it says the agreement is made between Heatherwood Housing Associates, hereinafter referred to as the landlord, and Tracy L. Castellanova.
Well,
So it seems to me on that, right there, it says that the landlord is Heatherwood Housing. Now, if I looked at the back, the individual person, Harriman, signs it as the landlord. So arguably, I suppose, she is the landlord. How is SK Management the landlord, or the lessor, which is the same thing?
but if you look at the lease that you just looked at, it says Heatherwood Housing Associates LP. Or Heatherwood Housing Associates is the landlord, correct? That's what you just
It just says, doesn't say anything besides Heatherwood Housing Associates. Doesn't say
That is-
Incorporated LLC. That's it. That's all it says. Heatherwood
That
Housing
is
Associates.
part of our plaintiff name. We brought the complaint on behalf of multiple entities between the owner and the lessor. If there was an issue, it's still covered by one of the other entities, being the owner or lessor. The appeals document.
Okay, so hang on. It says SK Management Company Incorporated Lessor and / management agent. I'm not sure what that means, and /, but whatever. And / management agent for Heatherwood Housing. So you're you're the management agent for Heatherwood. I guess doesn't Heatherwood have to bring the complaint?
And Heatherwood
Summary
did.
process complaint?
We have 3 entities named on it's not, so there would be an issue if, say one entity, say an owner brings a summary process case and they convey ownership in the property. That makes that summary process case defective. Of course, not going to be inclined to allow you to amend the plaintiff name. In a situation like this, we brought a summary process complaint, which is normally done in the housing court, naming 3 entities. We named the lessor, which is the property management company. We named the owner of the property, Heatherwood Housing Associates, and we named the DBA that the owner is operating underneath. So if you do locate an issue in one of those names, we have 3 entities named. And I believe that we do comply with Hatcher. And again, Hatcher reflected that an individual could not bring a case on behalf of a property management company. So I believe the summary process summons complaint is correct, as well as that's the entity's name on the notice to quit as well. It changed over to the, when it got to the appeals court, it's just reflected as SK Management for some reason, but my brief is filed on behalf of the plaintiff in the summary process case.
Okay.
So turning to the retaliation claim, I understand the housing court's very busy, but isn't it your burden to disprove the rebuttal presumption of retaliation?
Justice, I expected this question from you, having read the Moynihan decision. The housing court's decision was that the defendant didn't carry her burden. But assuming arguendo, assuming she did carry her burden.
Let's start with that. So why didn't she carry her burden?
So it's, the housing court just says in their decision she didn't carry her burden. I would allege that under 239-2A, she needed to demonstrate that she commenced or proceeded with any effort to obtain relief. She sent a letter, she sent an email. That's not commencing an effort to obtain relief. It was a 93A demand letter. Then I'd give you the benefit of the doubt, because that's usually the step in litigation. I'm gonna send a 93A demand letter. That lets you know litigation's coming. Just sending a letter, and there's still, my client testified that they never received that letter, and it was sent to the wrong P.O. box. But stepping past that, assuming she carried her burden.
Oh, do we have to step past that? Can we rely on that, or be where the judge, as a factual finding, said that an attorney acting on her behalf sent a notice of claim to the plaintiff's corporate office? Do we have to accept that finding as
it's tough.
Essentially that it was sent?
Yeah, he's the fact finder. So we have to do, so it says, in one place it says she didn't carry her burden. And you're correct. In that place, it does say that it was sent to my client.
If in fact she had sent, the attorney had sent the letter to the corporate office, would you agree that, and calling it a burden, I'm not sure it's right, but that she raised the
presumption.
Presumption.
Yes,
Yeah.
absolutely. They received that, she raised the presumption, but I believe I overcame the presumption by clear and convincing evidence. So that's the standard.
So if the judge doesn't apply that standard, then should we apply it or just send it back to the judge to apply the correct standard? Because the judge that's not the standard the judge applied here. And it's he's an experienced judge and he knows his business
absolutely.
quite
He applied
well.
the standard under 239-2A.
Yeah.
And that's what I believe, because he said she never shifted the burden, and I would assume that that's not by commencing or proceeding with an action to obtain relief.
It seems to me that the only interpretation of the defendant has not sustained her burden of proof that the plaintiff retaliated against her. There's two possible interpretations. One is that she hasn't sustained her obligation to raise the retaliation as an issue, which would then require your client to disprove it by clear and convincing evidence, right?
Yeah.
So that's one.
Yeah.
And the second one is that, which I can't imagine is the case, is that the judge here somehow thought that she had the burden of showing by clear and convincing evidence that in fact you had retaliated, because that's not the standard, right?
No, that's not the standard. That's the standard. If she demonstrates, and I think I just read one of your decisions recently with regard to, you had held that the retaliatory action didn't occur within 6 months period. So in that case, it was an unpublished decision. You held that retaliation did not apply. Here, arguably, she filed her complaint in January. The notice of quit came out in April. But the evidence that was taken at trial through testimony, there were pages, volume 2, pages 50 through 100, about these unauthorized occupants occupying the property. Had the burden shifted to me, at trial, we introduced exhibits of notices of lease violations from February of 2019 through March of 2023, ongoing behaviors at the unit, consisting of, as the appellant suggested, an unauthorized occupant violation in February of 2019, as well as some storage issues, which you pointed out, I understand. You said, it doesn't sound like a big issue. But part of the lease allows for termination for repeated minor violations of the lease. So if you look at the lease, you're allowed to terminate for one major substantial violation, which we would allege unauthorized occupants are. You're also allowed to terminate for repeated minor violations of the lease. And I introduced several exhibits at trial demonstrating several smaller violations of the lease prior to the issuance of the notice to quit. Thereafter, the notice to quit, September of 2023 was when my property managers, and what makes this case kind of distinctive than other unauthorized occupant cases, which is very difficult to prove, my caretakers live on the property. They live across the parking lot from the appellant. So they see what's coming and going every day. Further, my caretakers recently purchased a puppy. So they're out walking the dog in the middle of the night, training the dog. They're seeing people coming and going all night. So, and there's an allegation. In our notice to quit, we didn't name who the unauthorized occupants are. We don't know who they are. We're not required to name who they are. And if they change during the course of having unauthorized occupants, it doesn't make my case defective. My contract is with the tenant of the property. Now, further, to overcome a presumption of retaliation, clear and convincing evidence, I could have terminated this tenancy due to the action of her guests breaching the quiet enjoyment of the property. There's testimony that they're driving vehicles on the lawn, they're swearing at my caretaker, they're intimidating my caretaker and her children. So we would have had grounds to terminate her tenancy at the same time in a substantially similar manner. And I think the correct standard would be to apply under 239-2A. I don't think, she doesn't get to raise retaliation under 186-18. As I said, this is a cause eviction. Under 239-8A, she's not entitled to raise counterclaims. I would suggest retaliation under 186-18 is a counterclaim. So she may get the retaliation defense under 239-2A, but I don't believe she should get it under 186-18. And directing your attention to some of the decisions that this court has rendered, Justice Meade had in the Panetti v. Beauregard matter, that was an eviction, retaliation was raised as a counterclaim, but that was a no-fault eviction. So they're entitled to raise counterclaims in that situation, so the 186-18 standard would apply.
Are you aware of Campbell versus Abdullah, 105 Mass App 790, which was issued in August of 2025?
I don't have that one in front of me, Your Honor.
It says that rebuttable presumption is available even for cause evictions.
Okay. So I'm still going to maintain my position that I overcame the presumption with regard to, as I said, the behavior persisted.
The difference between 239, is it 239? Between 2A and 18 is that 18 is a counterclaim, and 2A
is a counterclaim,
and 2A is a defense.
2A is a defense. And then, as I said, I read your decision, South Bosley Elderly v. Moynihan, the 2017 decision based upon retaliation. That was an analysis under 186-18. I would suggest this situation is different. We overcame the presumption. If there was a presumption raised of retaliation, all the information to overcome that presumption was on record. The testimony of Julie Draws, volume 2, page 45 through 106, thoroughly details the issues that have been going on at this property. These aren't unauthorized occupants that we assume were there or that weren't causing issues. They were causing substantial issues around the property. As I said, we could have sent a notice to quit for breach of quiet enjoyment at the time. We introduced evidence that her guests or unauthorized occupants had been arrested on the property. They'd been there for an extended period of time. We had video evidence. We had testimony of them swearing at property management. We have evidence that the defendant failed to provide access to the unit. That would have been another ground to terminate her tenancy. And we also introduced evidence with regard to the defendant's guests using facilities that were designed for tenants. I would also note, while the defendant the appellant makes an argument, I think the court, in the housing court decision in two places, they didn't find her credible. In footnote 3, they said they did not find her credible based upon a text message that she admitted to sending about having an unauthorized occupant. And at the end of this decision, they said they didn't find her testimony credible. So based upon that, I would ask you that you affirm the decision of the housing court. I think they made the correct decision here.
Thank you. Thank you both. We'll take it under advisement.
Thank you, Justices.
Our last case is 25P511, Dispatch Communications versus Veterans Transportation. Mr. Flavin.
Good morning, Your Honors. Still the morning. Paul Kevin Flavin. I'm pleased to advocate on behalf of the defendant appellant Veterans Transportation LLC, which I'll refer to as Veterans. Your Honors, the thrust of this appeal regarding authority, the authority of an employee of Veterans, Reza Haydar, to enter into a contract with the plaintiff, Dispatch Communications LLC, for the providing of two-way radio service for veterans. Veterans operates the ride. You may have seen it around for the MBTA. It escorts typically senior citizens or disabled folks shopping or to doctor's appointments, wherever they have to go. Veterans had a particular geographical area. The Greater Lynn Senior Services, GLIS as we refer to it, had its own geographical area in the Greater Lynn area. For some reason, GLIS was no longer going to or able to operate that geographical area for the ride on behalf of the MBTA. The MBTA selected Veterans to step in and supply that service to that geographical area that heretofore had been serviced by GLIS. As part of that, the MBTA was switching over from analog devices, two-way radios, to push-to-talk digital communication between a dispatcher and, telling the driver of the ride who to pick up, where to pick up, and how many people to expect. So it was known that when they took over for GLIS, they would take over the two-way analog radio system on a temporary basis.
We actually understand the factual underpinnings. Maybe be helpful to get to your argument.
Thank you, Ron. There's two kind of authorities that Mr. Haydar could have had on behalf of veterans, actual and apparent. Actual authority, as you well know, is granted by the principal manifesting intentions or authority to the agent to enable them to do something. Apparent authority is a third party sees the principal communicating to the third party, giving that third party an indication that the employee has the authority to act in the manner that's...
So you say in your brief there's not a scintilla of evidence that Haydar had the authority to sign the contract.
Correct, Your Honor.
Didn't Uncles, who's the owner, right?
Uncles is the owner of Dispatch, yes.
He testified that Haydar had the authority to sign.
He did, Your Honor, and that's based upon the fact that in the pre-printed authorization above the signature, where Mr. Haydar signed the contract, it says that he is authorized to sign the contract.
So Haydar also has signed that he's authorized to sign. Didn't Uncle sent them there to do the deal, right?
Correct, Your Honor, but Mr. Uncles can't take a representation from the agent to establish apparent authority. It has to come from the principal. I can't walk into a dealership and...
Why Uncles is not the principal?
Uncle is the principal of Dispatch.
Yeah.
The plaintiff.
Well, in order for him to think that Haydar has apparent authority, that has to come from the principals of veterans, giving Uncles the idea that Haydar can act in this fashion.
So wait, I think you're making an argument of a law that I'm not familiar with. I thought it was that if an agent comes, goes to somebody and says, I have the authority from, they tell me that I have the authority to say, I'm the head of IT and I'm negotiating this contract and I have the authority. That's not good enough. He's got to actually confirm it with the principal?
To have apparent authority, Your Honor, yes.
So the person, you have to confirm with the principal. You can't just base it on the agent's
Well, and again, Your Honor,
actions.
I don't know if it's confirmed. You could have prior dealings with the principal. They said, hey, I'm sending Haydar over to sign the contract regarding the radio service.
So the burden is on the person who's relying on the apparent authority to make sure that they have actual authority? I mean, isn't that you're saying they have to make sure he's got actual authority before they think he's got apparent
Again,
authority?
Your Honor, you're kind of like confirming after the fact or making sure. There has to be some manifestation from the principal of veterans to Mr. Uncles that Haydar has the ability to sign this contract on behalf of veterans. Now, the actual authority was testified to. the general manager of Veterans, and Hayter himself testified his authority was limited to contracts not exceeding $5,000, and he couldn't sign long-term contracts. Now, here's the rub here, okay? Hayter was going over to sign, to acquire two-way radios and to sign up for a service, the exact same service that Gliss had. Mr. Uncles admits that in testimony, that that's what Hayter told him, I'm coming over to sign it. He confirms at Exhibit 9 in an email. He says, when I gave you the same deal as Gliss, the judge found on page 4 of his memorandum of law deciding my motion for a new trial or a judgment notwithstanding the verdict, I'm quoting, Uncles informed Hayter that the terms of the contract would be identical to the terms of Dispatch's contract with Gliss. Hayter had the authority, both actual and apparent, to go over and to enter into a contract to receive the same services under the same terms as Gliss. Now, what happens is, he goes over, the amount is the same, confirmed, $3,500. That's less than the $5,000 his authority. And Hayter thinks he has the authority to sign this contract and signs under where...
Well, putting authority aside, why isn't it ratified after Veterans makes, I think they make 3 monthly payments?
Actually, they made more than that, Your Honor. It's not ratified because Mr. Hayter thought, and the people at Veterans thought, that he had signed a contract that was month to month, the same agreement that Gliss had with Dispatch Communications.
Did the contract say it was month to month?
No. In small print on the reverse side of the contract, with a lot of other terms and conditions from indemnification to venue provisions, it says it's a 36-month term. Hayter didn't realize it was a 36-month term. When he brought it back to Veterans, no one at Veterans knew it was a 3-year term, and they continued to pay month to month as Gliss was doing. Gliss's contract, Mr. Uncles testified, was oral month to month. Now, the fact that what demonstrates, you can look at the circumstances, what demonstrates that Mr. Hayter didn't have the authority, he's going over there knowing that these two-way radio systems are a backup for their push-to-talk while they incorporate the push-to-talk. So he knows it's temporary. He knows what the terms of Gliss's contract is. He's going over there to pick the radios up and to engage the same service that Gliss had, which was, we'll pay for the use of the two-way radio dispatch communication system so long as we use it. In other words, month to month. In fact, my client terminated in October and paid for the rest of the quarter through the end of the year. But the fact of the matter remains, Mr. Uncles testified that Hayter was coming over to obtain the Gliss services. They were stepping in for Gliss. Gliss had already had a contract with Dispatch. Veterans was simply stepping in to provide the service for the MBTA, and the intent was under the same terms as Gliss. There's a lot made of the fact that thereafter, part of the ratification, that Veterans incorporates into an MBTA contract that the MBTA will reimburse them for whatever costs they're charged by Dispatch for the two-way radio communications. Yeah, on a month-to-month basis. As long as they use the service, just like Gliss had a contract with Uncles and with Dispatch, just like that, we will pay for the service as long as we use it, everyone knowing that it's temporary because Veterans is taking over for Gliss and they're transitioning to a push-to-talk digital method of communication.
Was the MBTA reimbursing Veterans for the payments?
They were, so long as the MBTA had Veterans retain the two-way radio system as a backup system. Once the MBTA told them to terminate the two-way radio system, the MBTA wasn't going to pay for it anymore. Everyone under the assumption that they were taking over for Gliss. Expressly, Hayter testifies, I was going over to take over the Gliss contract, or the services, not the contract. And Uncles admits, he says, I was giving you the same deal, Exhibit 9, it's an email. After they tried to terminate, he says, it's in context of saying, I had to re-up a lease on the Prudential Tower for my radio towers. Dispatcher leases the roof of the Prudential for radio towers. He says, I had to re-up a lease based upon this. Well, no, he didn't. He had a 5-year lease that was already in effect, as it turned out, a discovery, and it came out at trial. So the key here is, and that leads into the liquidated damages argument. Mr. Runkles had 12 other customers using the towers at the top of the Prudential. So he was going to continue to lease that whether or not dispatch used the two-way radio system or not. So that the damages, i.e. paying for 3 years, monthly basis, is far disproportionate than any damage that dispatch suffered, because evidence at trial proved he had alleged that he had to enter into leases and maintain leases. The leases were already in effect. In fact, the Prudential lease, a year and a half after we terminated, he re-upped because he still had the other dozen people using the two-way radio system and needed dispatch services. But again, Your Honor, the key here for me is everyone knew, Mr. Runkles, Mr. Hayter. Mr. Hayter did have authority to sign a contract. He did have authority to sign a contract for $3,500 a month. He did. But he did not have authority to sign a contract for 3 years, which is beyond the terms of the dispatch GLIS contract that Veterans was taking over. And it's clear, the actual authority, he cannot sign a contract for a term of years or in excess of $5,000. They make an argument that same day he signed a contract with dispatch to repair some radio equipment. It was $4,000 and change. It's less than $5,000 one time. The general manager and Mr. Hayter both said, my authority is contracts for less than $5,000 and I can't do long-term contracts. That is borne out by the fact that he was going over there. Uncle admits it, Hayter states it. I was going over to take over the GLIS service contract, or the terms that they had, same terms.
So he was authorized for certain transactions, just not others.
For certain transactions, he testified the limit, and the general manager testified his limit was he couldn't sign contracts in excess of $5,000, nor could he sign long-term contracts.
Did the plaintiff, is there evidence that the plaintiff knew that?
I'm sorry, Your Honor?
Is there evidence that the plaintiff knew that?
The evidence was the plaintiff's, his contracts were basically month-to-month oral contracts with the people, his customers.
But did he know the extent of Hayter's authority?
I'm sorry, Your Honor?
Did he know the extent of Hayter's authority?
Well, again, I do not know if Uncles, it wasn't apparent whether Uncles knew the $5,000 he couldn't sell on long terms. What Mr. Uncles knew was Mr. Hayter was coming over with the authority to enter into the same arrangement that GLIS had, because we were stepping into GLIS's shoes for the MBTA. Only reason we were there. And based upon that, Your Honor, and it's undisputed that veterans paid not only through the time they terminated, but several months after that. So the only question here is, in my mind, did Mr. Hayter, based upon all the facts and evidence, have authority to enter into a 36-month contract, which was in small print on the back page? Now, I'm not going to suggest that Mr. Runkles was slipping this in to get the 3-year contract signed. GLIS didn't have a written contract. It was oral, month to month. Mr. Runkles knew veterans/Hayter were coming over to pick up two-way radios to temporarily use the service till they employed the push-to-talk. And he acknowledges that Hayter told him, I'm getting the same, if I might, Your Honor, question. I asked Mr. Runkles, quote, Mr. Hayter informed you that Veterans was going to take over the same services that you had provided to GLIS. Am I correct? Yes. It turned out to be a 3-year in the small print. Thank you, Your Honor.
Thank you. Ms. O'Leary.
Good afternoon, Your Honors. Carol O'Leary for Dispatch Communications. Just a couple of points of factual dispute. Before Mr. Hayter signed this contract, he had a conversation by phone with Mr. Uncles, and Mr. Uncles testified to this, that he told Mr. Hayter it would be a 3-year term at the same rate that Gliss was receiving, but that it would be a 3-year term. Mr. Hayter never provided any objection. Mr. Hayter appeared that day, sent by veterans, to obtain a service that was vital to their performance of their contract with the MBTA.
And you said that was testified to?
Yes, he showed that day to get the service, to pick up the radios from Gliss and to arrange for service from dispatch. This service was a necessary component of veterans' contract with the MBTA. They were not in compliance with the MBTA unless they had this service. At no time did Mr. Hayter tell dispatch or Mr. Uncles that this was a temporary situation. Mr. Uncles testified that never occurred, and I don't believe that Mr. Hayter even testified. He was asked, did you tell them it was temporary? And the answer was no. So Mr. Uncles told him before he came in it was a 3-year term. Mr. Hayter arrives that day, admits that he read the contract, which contained a 3-year term. The contract says, I have the authority to sign this. He signed it, he got the radios, he left. He brings that contract back to veterans, and veterans begins paying on it.
Was there other evidence of his authority besides what's written on the contract?
Yes, first of all, he was the one that was designated to come pick up these radios that were critical to veterans' performance of their contract. Also,
What's the evidence that he was designated?
he was the person that reached out to dispatch to say, I need to get these radios done and I need to get the service on these radios.
So it was his representation?
Yes.
Because, I mean, Mr. Flavin said, and surprised me, but I think he's right, that, and it's in your brief, apparent authority is created as to a third party by written or spoken words or conduct of the principal. So what conduct of the principal do we have?
The principal is veterans, and veterans sent Mr. Hayter to go get these radios that were critical to their operations. But even if we, and Your Honors, even if we get aside from the part of authority, ratification absolutely occurred here. The contract was signed, it was brought back to veterans. Veterans paid on it with no objection. No one made any objection when the contract came back to veterans. Veterans paid on it for 6 months with no objection.
They thought it was a month to month.
That's what they say, Your Honor. Of course, that's a very convenient excuse. They have a contract that says it was for 3 years. Mr. Uncles told Mr. Hayter it was going to be for 3 years.
So was that a jury question?
That was a question, I'm sorry, it was not a jury question.
Not a jury question.
No. But Mr. Uncles did testify that he told him that it was going to be for 3 years. Mr. Hayter testified that he read the contract and signed it, and that contract is for 3 years. It's only when this contract was no longer convenient for them that this issue of, well, we thought it was on a monthly basis came up.
What was the monthly rent?
The something like $3,951, something to that effect.
So the 6 months of payment was over $5,000.
It was about $10,000, yes. I think it was $10,000 twice. They made a quarterly payment and then another quarterly payment. The interesting thing is also the ratification by including this specific amount. It's a very specific amount. I believe it's $3940.41. They included that in an amendment to the MBTA contract that occurred after they tried to terminate with dispatch. A month afterward, they signed an amendment to the MBTA contract that shows that specific amount being incorporated, and the MBTA is saying, we will reimburse you for that amount every month for the rest of this contract for these services. So they not only, they could have gotten that money from the MBTA, and the MBTA contract was never amended. There was an argument by my brother that it was only until the MBA told you no, that no longer, we're not going to continue to pay that. That never occurred. There was no amendment. So as of today, the MBTA is still obligated to pay that monthly amount until there is some amendment that says they're not. So they had that benefit, that ratification included in their principal contract with the MBTA. And I do think my brother is talking about, there's discussion in the brief about the Marcoux brothers. But that's missing the point. The principal here is veterans. It's not the principals of veterans. Otherwise, that's disregarding the corporate entity. The question is what the corporation was doing, not what the Marcoux brothers were doing. And the corporation was sending Mr. Hayter to get this service and having Mr. Hayter sign another contract the same day for an unexplained amount. It did not say, I know there's this talk about the $5,000 limit, but the contract that he signed the day that he came in for additional services had no amount on it. It could have been for $7,000, could have been for $8,000. There was no amount on it. And at no time was dispatch advised, well, wait, I can only sign this purchase order for the additional work if it's under $5,000. That didn't occur. So there is ample evidence that dispatch had facts and circumstances to rely on in this authority, and the fact that veterans benefited from the services that dispatch provided and that veterans ratified it. With regard to the liquidated damages provision, the veterans admitted the first prong in their motion for a new trial. They admitted that damages would be difficult to calculate. So then the question is whether they're excessive. And there is actual precedent that says that if the only thing you're looking at is what you would get under the contract if it wasn't breached, that's not excessive. NPS LLC.
Why would it be difficult to calculate? Wouldn't it just be the monthly payments that they didn't receive?
And that is what the liquidated damages provision, Your Honor, was. It's
Right.
just the payments that they did not receive under the contract. It's no more. But I think the veterans wants to pay like for a proportion of the leases, and that's a difficult thing to do. You have space, these leases are on top of the Hancock Tower. It's a difficult thing to determine how much of this antenna lease is due to this client and how much is due to this client. Damages were difficult to ascertain. That's why it's only the monthly payment for the term of the 36 months. And that under recognized case law, that's a reasonable liquidated damages provision. And that's all I have, Your Honor, unless you have any other questions.
Well, seeing no other questions, thank you. Thank you both.
you.
We'll take it under advisement. With that, I'll bring to the close of this session. I'd like to thank my panel, our law clerks, our court staff, our court officers, and our excellent timekeeper. And we will stand in recess.